Is a will enough? Is that the only document that one needs?
So if you purely look at it from an asset perspective, right? A will takes care of your immovable property, valuables, commodities. A typical Indian family has a lot more than that. And there is something which is called a concept which is called the letter of wishes.
What is the most common mistake that people make?
The most common is obviously not to do anything about thinking about either your previous generation or the next generation. We as Indians don't like to think about what if things go bad.
What is the ideal age that may be in a household to draft a bill?
I don't think this has got to do with age. I think it has got to do with when you have something to leave behind.
Is succession planning always just downwards? Is it sideways? Is it upwards? Is it?
But people
what
do
is
it downwards, but you shouldn't just do it downwards, because today something can happen to me, and then what happens to my mother?
So how do you do that?
One question I have to answer is who is dependent on me.
Yeah.
The second question I have to answer is whether dependent or not, would I like to leave somebody to something?
You fucked me.
I changed my mind, Kendall.
When?
In a will, you have complete flexibility to decide who you give your self-acquired property to. But if you have inherited property which has come to you from 2 generations before, it will follow the rule of law.
Is there anything else that a person should be aware of or do?
The person may find the will, doesn't find the property card and doesn't find the property document. What are you going to do with it?
Namaste and welcome to this episode of the Oddcast show. As we always bring you content that's odd and relevant, today's topic is exactly that. It's about succession planning. And the reason it's odd is because we Indians or people at large generally view death as a taboo topic. And because we view that as a taboo topic, we don't plan ahead, we don't plan for the future, we don't, our children don't know where the money is, they find so much trouble in trying to access that money, after you're gone. To discuss this odd topic, we have Radhika Subhash ji with us. She's a very big lawyer from Pune, and she's going to talk us through about what are the do's and don'ts of this, and what are the simple mistakes that people make generally. So welcome to the show, ma'am. I hope you're comfortable and you are happy to be here. We've chased you a lot. You've made us chase you a lot.
I know. I'm sorry about that, but I'm very happy to be here.
I'm glad we're finally doing this very, very important episode.
Thank you.
So ma'am, as we were talking as an introduction and offline also when we talked about, there are a lot of mistakes that people make generally, while they are planning successfully or their succession planning, but they don't even plan. In fact, most people don't even plan. So what is it? What is the most common mistake that people make?
So the most common is obviously not to do anything about thinking about either your previous generation or the next generation. Death is an inevitability. And other than death, also some sort of an disability, some sort of an inability to work in the legal realm is also a possibility. So what happens when you are legally not recognized as a person who can contract or who can do something for your family? What happens in that status? So people don't think about it, and then don't read about it, don't take the right advice and do anything. So if you ask me, toughest mistake is to not do any mistake.
What are the other common mistakes that people make?
Google down wills and write them up, thinking that they've taken care of things. Make nominees to bank accounts and thinks that they have taken care of everything, but nomination doesn't solve anything. Think about only the next generation. But, COVID has taught us that you can have a younger person pass away and elders left behind. So what happens to them? How do they access easily the wealth, the finances, the assets of the company or the family? These are the normal ones. Then again, even in separation, in India, this prenuptial thing is not really a done thing. It's not acceptable. But what happens in separation? What happens to the children? How are they provided for? Right. So these are we as Indians don't like to think about what if things go bad. And that's really the reason why we don't make available anything for when it goes bad.
Right. So one of while I want you to take us through the steps as to, what does a family or an individual do to protect his or her wealth and make it available easily to the next generation. While I'm going to do that during the episode, you've raised a very interesting point that, even a younger person could pass away and there's an elderly left behind only. And that person has not been planned for or accounted for, and that's why that person cannot access the wealth or the money. So as I understand from you that, succession planning should not be downwards, it should probably be circular.
It's a circular
So can you
reference,
explain
always.
that, what that means?
So anytime in the setup that we live in, you will have people who are peer to you, who may also be dependent, people who are obviously elder to you, who are also dependent, and people who are obviously younger to you, who are also dependent. So which is why I call this a circular reference, you know. It could also so happen that you have somebody who's dependent on you, who you would like to provide for, who's not really family. A classic example of this in the Indian parlance is, let's say there's somebody from the village who's moved along with you to take care of your children when they're younger, and that family has kind of tend to live with you. You don't think as people who would really succeed from you anything, right? But what happens to that family who's moved from a remote village, mostly illiterate, come to the urban India, settled in an outhouse of your house, and then what happens?
Dependent on you.
Completely dependent, being loyal, and most importantly, you want to leave something for them, but you don't think about these things. So I think the circular reference point is think through a circular reference. Two aspects: who are dependent on me, to what extent, and who would I like to leave something for. There could be children in the family or nephews and nieces who are not really dependent. They have their own set of parents, but you may want to leave something of yours to them. So these two factors need to be factored in when you do your succession planning.
Also, like, generally, typically, when I talk to my friends and, family, etc., the typical mindset is that, will, so, you make it like, in your old age only. But, the fact that COVID hit us, such a big pandemic hit us, and so many young deaths are there and so many unnatural deaths are happening. The question is that what is the right time to make a will?
The moment you have a single asset in your name, or the possibility of getting a single asset in your name.
So it's at that early stage you make
I made my will when I was 32, and I think I was very, very late.
Really?
I was very, very late. And I come from a typical middle class family where your first asset is always on loan. But even then I made a will because I realized that if I die, my child may not have enough to pay off the loan. And insurance is not the answer to everything.
Right.
So I made my first will when I was 32. But I think you need to think about it not from a death perspective, but from a continuity perspective. If you look at it from a continuity perspective, where typical parents like you and me, we always want to put our affairs in order. This is just an extension of that. The way you would do your medical filings, the way you would keep your cupboards all right, the way you would keep your files digitized and all of that. This is just an extension of that. So keep your affairs in order.
But is a will enough? Is that the only document that one needs? Is that enough? What else is required?
So if you purely look at it from an asset perspective, right? A will takes care of your immovable property, valuables, commodities, your investments and all of that. But a typical Indian family has a lot more than that. And there is something which is called a concept, which is called the letter of wishes. It is mostly known a concept where you do private trusts. What is a letter of wishes? Now, one is a diktat to your executor that I am leaving this, ensure that so-and-so owns this and all the paperwork is in so-and-so's name after I die. But there's also a letter of wishes that you would like to leave around that, look, I would like you all to follow this, or I would like you all to continue to donate to something like this. I would like you all to do certain charitable organizations. I may not know the names, but could you work towards this charity? Could you give your time towards these charities? So I always think combination of a will, register it. I know registration is not mandatory in law, but register it because the court process is easier once you have a registered will, and then a letter of wishes to kind of support the whole thing.
But is that letter of wishes legal? Is it a legal document that has to be abided by?
Not really, because what is legal needs to go into the will. What you would want it to be 100% enforced needs to go into the will. But I today have 100 saris. I don't want to enforce what my daughter or what my niece or what my daughter-in-law does with the saris. But I would love to leave a direction out to a certain extent to say that, look, don't wait for them to tetter out and tire. If you're not going to use them, take Goonj or any equivalent NGO and donate. Now, would I want somebody to sue that person for not doing it? No. But would I like my desire to be known? Yes. Why not?
So it's more like a statement of, what your wishes and desires are.
So it is a letter of wishes, which you don't look at it from an enforceability perspective.
It's a very interesting point because I've never heard of that.
Yeah. But it's something that has come out of the trust. So when you do a private trust to manage properties, we have a letter of wishes that is given. But it is equivalent to even people who don't want to do trust but want to do a will.
So you spoke about making wills at the start with Google Docs, but there are obvious claims that can be made against that also by relatives or whoever wants to take whatever is written in that will. So how exactly do you make a will that would legally stand for whoever it is?
So there are 2 or 3 basic components of making a will under the law of wills. One is it should be written to the largest extent.
Where?
Now, it doesn't have to be in English or in any other language, but it has to be written. It has to be testified. So what happens is that you need to have 2 witnesses who don't know the contents of your will, but they need to witness you making a will, because you are not going to be there to fight for the effects of your will later.
Right.
So you need to have 2 male or female but major witnesses, people who have attained majority, to say, so and so did make a will on this date and I was there to testify to that. You need to have a doctor's certificate of that day, which says that I'm aware that so and so person is making a will today, and I have checked on his mental and physical health, and he is of sound mind
to make that will.
To make that will. And then, of course, this is more. So this is need to have the elements I said. The good to have is register it. It's not mandatory. It's not mandatory because in India today, everybody needs to make a will. Now, if you make it more tedious a process, the rural India doesn't even have access to anything. Forget a sub-registrar, even a bank. So therefore, the law has not made it mandatory, but register it because the process later in court is much easier. So I always ask people to register a will. And then, of course, make very, very categorical, simple language in the will. There was a person who came to me once, interesting story. He said, I would like the property to go to my wife, but if my wife remarries, then I would like it to go to so-and-so. But if my wife doesn't remarry and if she gets into a live-in, then I would not like her to have it. And then it went on. And then after my wife, I would like that property to go into so-and-so. And I had to stop him in saying that your will is only a one-time transfer. Once you say, I would like my wife to have it,
then it's up to her.
Entirely up to her. And you cannot then dictate what happens if she does this or she does that.
Right.
Nothing is conditional. So as far as possible, keep it simple. Remember that it's a transfer. In your head, it is like a transfer. It's one shot you're allowed to do it at for every asset of yours.
Right.
So if you follow these 4 or 5 things, and though it is not mandatory for a lawyer to do it, I still advise that please take a good legal advice when you're doing a will.
So when you're writing, I will write it where exactly? In a diary?
Yeah, no. You need to write it on those papers, and because you need to go and register it.
Right.
Advisable to register it. But I know people who have done wills and put them on blockchains. Yeah, because that is the best way to. Well, I have yet to see the enforceability of it. But I don't know why it shouldn't be, because the Information Technology Act does recognize evidence of that form.
Right.
You can't register it because there is no digitized record registration in the country yet. So you can't register it. But I don't know why it should not be doable. It should be.
You said you drafted your first will at the age of 32, and you said you were also late for that. So what is the ideal age for whatever gender, whatever role of a person that may be in a household to draft a will?
I don't think this has got to do with age. I think it has got to do with when you have something to leave behind.
Okay.
Now, it can be an asset. It can be a movable property, immovable property, so many things, right? So at whatever age you think that, or it could even be a liability that you do not want the child to take the full force of if something happens to you, right? So it could even be a liability. So whenever you are at whatever age in life you think you attract a liability or an asset to your name, I think that's the right time to do it.
So like one of the questions I had, ma'am, was that, let's say if I make a will today, should I be sharing it with my family, my immediate family, my children, my mother, who I live with? Should they be aware of the contents of the will? Yes or no?
Well, I would always say yes, because you're doing it for them.
Right.
But it all depends on case to case, family to family. If you're going to think that there is going to be a controversy around it, if you think that you're doing something which one person may not like, so then probably then do the whole thing, then counsel them, then make them understand. Don't make it like a diktat. If you're making like a diktat, please put it in a sealed envelope and keep it with your executor.
Right.
But again, no legal answer to that. if you purely ask me from a quasi-legal advice, I always say, no, please disclose. Let them know,
And
make them a party to the whole thing.
right. And can I, let's say, okay, today in whatever, let's say, somebody has lost his spouse and he or she is worried that, okay, something may happen to the leftover spouse as well. And, the children are young. So, let's say that person makes a will and, he makes it in a certain state of mind or a frame of mind today. And 10 years later, he feels that, okay, one of the children is not turning out to be as what he had expected him or her to be. Can that will be changed then? Can I keep changing
I'm
that
just
will?
in the process of changing my will right now.
Okay, so that's easily doable.
Yeah, absolutely easily doable. But the only thing is, if you have registered the previous will, then you need to mandatorily register the second will. In that, you disclose that there is a will like this I made before. That will is removed from the records of the sub-registrar, and then you register the next will.
Right.
You follow the due process. And just on that one point, that never make a will after as a effect or as a rebound to anything. It's like a normal day of putting your affairs in order. Something doesn't have to happen for you to make a will.
Like prevention is better than cure.
Yeah. So I always say that the normal way, like you today would look at your portfolio and say, look, oh my God, the shares have dropped. You would go talk to your broker or talk to your portfolio manager and say, can you just move from debt to equity and this? Why would you not think of your asset management in the same breath?
Right. And typically, as we were talking offline, you also mentioned that the will has got nothing to do just with money or monetary assets or immovable property. What else can you cover in the will? Like, can I put in like paintings, art, etc., all those things?
No? It is painting arts for sure. Any sort of inventory for that matter. You have antiques, you have awards. There are celebrities, there are sports persons who have awards. What happens to those beautiful, fantastic achievement medals? You have memorabilia that are given to you. I have a fantastic celebrity I know who has not as much wealth, but the legacy through the awards that they have brought. You must put it to someone who would value it equally.
Who would take care of it?
Who would, well, that again, I always say that once you put it in a will, you don't worry whether they take care or not take care of it. Who you want to give it to. It's as simple as that. What he or she does with it later is really something you should stop yourself from thinking about. You're anyways not going to be there when they own it. But yes, who do you want to leave it to? So you have that. But again, that still comes in the assets. What I was talking about I was talking about those things which are not really tangible.
For example?
So as human beings, we need a sense of attachment and a bonding to where did I come from? And assets and financial security is only one part of where did I come from? What is mine? What belongs to me? What has my family left for me? What did my grandfather earn? What did my father earn? But the other things are where I come from. What was my family all about? What have they been through? What is the value system that they followed? Were they zamindars? Were they the good zamindars? Or were they the kind where there could have been a story of an atrocity in my family? Do I want to, in a way, rectify it for the newer generations? It is the story of history that needs to pass on, which is what is a child or the next generation or the third generation really bonds with. Money and assets are just one aspect of the whole thing, which the law lets you deal with in a particular manner. But there is so much more. Memories, for that matter. My grandfather was a freedom fighter. And my biggest worry is that because my child was born when he was no more, my child doesn't know the story of what a freedom fighter really is.
True.
And I would like to pass on that to him or her.
That memory.
It's a memory. And then how did they behave in a particular manner, in a particular situation? It's a story of courage. It's a story of bravery. It's a story of being resilient, of being true to a certain value system, to a certain ethical system of the society. That he did not side with the British and take a cozy job, but he went out, got beaten up, got shot at, got jailed because he believed in a particular way of freedom. How else do you pass that on?
Right. So I have a very different kind of question here where let's say that, okay, somebody's family has been owning a particular type of, let's take for argument's sake a sari, which is very expensive. It's got gold on it, etc. It's a 200-year-old heirloom. and it's been passed down from generation to generation. And then the last person holding it passes away, and in his or her will, it's not mentioned that who's going to take it. So how does the family access that? Or can the state take over that? Like, is there any case like that?
There are rules around heritage properties which do attract by size, and yes, the state can, and state doesn't take it over, but it decides that it has more value ascertained to it than for one particular family. There is history around that heirloom that they would like the people to know. For example, heritage houses. Now, there are houses which are heritage properties in Pune. I don't know if that, that place in Yerwada, there's a house where, not the Aga Khan Palace. Before the Yerwada main signal, there's a small little hillock on which there is a small temple. There's a beautiful house there. And that's a heritage property, which means that family can use it, but can never do away with it, bring it down, renovate it, do anything new, because it has heritage value to it. So any heirloom, any asset, if it has a heritage value, the state may be able to claim it for the historical importance.
But even if it is mentioned in the will?
Yeah.
They can still claim it. All right. Another question I had, ma'am, is that let's say a child who's just say, a minor, like he's 10, 12 years old, and there has been no succession planning. I'm giving you two scenarios here. Let's say there has been no succession planning by his parents, and both the parents meet with an unfortunate accident and they pass away, and the only child is left alone. How does that child as a minor access the finances or, all the things that are left behind by the parents? How does that child do it without a will?
So there are two concepts, right? One is testament, which is a will, testamentary document, which is a will. One is also the intestate law, which is when you die without making a will. In which case, in India, succession is guarded by the succession laws, which
so
are
the next
personal
of kin
laws.
will.
Yes. So depending on if you're a Hindu and you are under the realm of Hindu Succession Act, then the rules of Hindu Succession Act will apply. But if you're a Muslim, then the rules of Muslim Succession Act will apply. If you're a Parsi, then the rules of Parsi Succession Act will apply. If you are a cross-faith marriage and you have registered the marriage under the Indian Marriage Act, then the Indian Succession Act will apply. So not having a will does not mean that you don't get the property. It just means it becomes all the more tedious and difficult because the court gets in. You have to go and get a succession certificate. The court will go to all the processes to identify that you're the real legal only or two children. There are no, by the way, illegitimate children are protected by law as real children when it comes to succession, right? Unborn child is also protected, you must remember.
Oh, really?
If somebody is 9 months pregnant and loses, then that child is also protected under the law. Then the process of law comes in and that the act derives what you get later. It's not that you will not get it. It's just much more tedious and much more longer period for you to get it.
So you made it very clear that insurance and couple of wills may probably not solve all the problem. And is succession planning always just downwards? Is it sideways? Is it upwards? Is it?
But people do
it
it downwards, but you shouldn't just do it downwards because today something can happen to me, and then what happens to my mother? I would like to leave something to my mother because she's my mother.
So how do you do that?
So like I said, right, you decide first who is dependent on you today, as I'm a 46-year-old adult. One question I have to answer is who is dependent on me?
Yeah.
The second question I have to answer is whether dependent or not, would I like to leave somebody to something? So it is a capability issue, it is a willingness issue. And that is the circular reference that you can draw. Now, one thing you have to remember is that there are two types of properties you have in life. One is inherited property. One is self-acquired property. In a will, you have complete flexibility to decide who you give your self-acquired property to. But if you have inherited property, which has come to you from 2 generations before, it will follow the rule of law. So today, if you're a Hindu succession and you have inherited property that has come to you, say, from your great-grandfather, and I think it is 2 generations before when you make it inherited, it is not just your father's property. You cannot decide that another sister or another bua or another aunt of yours does not get under the will. So your full flexibility is only on your self-acquired property. Your inherited property, you can deal with it as a karta or as a manager of the family, but under the realm of law, you cannot simply say, oh, I will not give it to the daughter, which you can do with your own property.
But in this kind of inherited property, like, I do need to, I have the ability to decide who it goes to.
Correct. But within the 4 corners of the law. Like
so
if
what does that mean exactly?
So if under the Hindu Succession Act, the daughter and the son get equal rights to the property. which means what? Let's say it was your great grandfather. So your grandfather had a sister, which means ideally it is 50-50 there. Then the only thing that came to your grandfather was just 50. But let's say the sister allowed the brother to take care of it and she continued to stay with the family. The great grandfather sent it to your father, and your father again, maybe the sister had one child, but because it was being provided for, maybe the property cards and the land cards went on in one name. But ideally speaking, in the law, she had equal right. Now, let's say your
But
father.
does she still have that right?
Of course, she has that right. That's what the law protects under the Succession Act for inherited property. Now, let's say your father decides, okay, I would not like to give it to my nephew. Okay, my nephew does not deserve it. And takes the entire property and distributes it among you and your sister. Whether that great grandfather's sister is alive or not, by rule, that child, that nephew can actually
Claim it.
very legally claim the entire thing, 50 going from there. So when you buy property, right, when you go and buy pieces of land and parcels of land, we do something called title verification for 30 years and 50 years, right? You actually go through the family tree of everybody who owned, and we make tremendous effort to find, did so-and-so have a sister who may have died now but left a child behind? They may not have written her name in the property card, but by law, her children can come and claim it.
Very interesting. I never thought of it this way. Also, ma'am, there are, we keep hearing in papers, larger families, have a lot of wealth, etc. They make a will, the grandfather has made a will, passed away. And then, the two sons are disputing that will in court. So how does somebody protect himself from a dispute in a will? Like, and on what basis can a will be disputed?
Yeah, mostly it is done of unsound mind or not done properly or was coerced into making a will. There was undue influence. One brother was taking care of the parents for so long that he made sure that they left everything to him. Mostly those are the reasons for disputing a will. There are also certain ones that this is not my father's signature at all. He has gone inside. There are wills made which are made at deathbeds. There are wills which are made in hospitals and ICUs. Those are the most easily contestable ones because you are probably not very sharp-minded when you're doing with a ventilator or an NAV on your. Of course, with a venti you can't, but you have a non-invasive ventilator and you're signing a will. Easy to contest something like this. Therefore, follow the very, very strict process of law. Take fantastic legal advice and to the T. Can you always make sure nobody challenges it? That's not possible. Anybody can challenge.
So anyone can challenge anyway.
Can you make it difficult for that challenge to come through? I think yes.
So let's say, someone makes a will and, passes on, and that will has, where there's equal distribution of everything, all the assets, wealth, money, etc., and all your memories, etc., everything has been put down to perfection in that. That will can still be challenged, is what you're saying, by the next of kin.
Yes.
Right. So what is the time frame for that challenge? Does it go on and on?
The law of limitation is cause of action to 3 years, I believe. But that's not the point. The point is that are you challenging it on the basis of inheritance law? Then you can challenge it any point in time. It's about when the person who wants to challenge came to know about the will. There are so many times that the person may not even know the death of that person. Forget the effects of the will. And then they find out later. You can still go and challenge and it will be entertained by law.
So it's timeless. Like if on inheritance, you can challenge the will at any time.
Well, you can't put it blankly. It's timeless. But yes, the law of limitation will not protect a wrong to that extent. They will not say, look, this was 10 years ago, so therefore let it go. It becomes more difficult by the effects of time, but it does not go away.
Right. So as you mentioned, the steps to doing this is that first of all, you have to approach it in a manner that, it's something to do with continuity, where you're looking at it and from that angle, rather than, worrying that, mujhe kuch ho jayega, to main will bana lo. It's not that. You don't need to have some event happen to you to make a will. You can make it at any time.
No, you shouldn't wait. And in fact, when you have an event happen, then you should please pause for some time, come back. You have to have a very, very steady head when you're doing these things. It cannot come in from, it's a simple thing that we tell our kids, right? Rebound from a relationship, don't get into another one. This is also the same thing. You're leaving something behind when you're not going to be able to tell what you meant or intended by that. So always do it when you're not from a grief perspective, not from an anger perspective. Do it like you would treat any other mutual fund investment of yours.
So that's A. That's one is making the will when you're in sound mind. The second thing you mentioned is, letter of wishes, where you can put down certain things that, this is the way you would ideally like, your legacy to be carried on and, your assets to be managed or, whatever it is at home. Is there anything else that a person should be aware of or do?
See, banks recognize nomination first. Now, nobody's going to go and argue that nominee alag hai, will alag hai, do something. Do your nominations correctly. Do your insurance coverages correctly. Also, if you have a situation which is non-controversial, many families, like I have a family where I know there's not going to be any controversy over the whole thing. I would rather leave the copies, the papers, the original papers of everything with that either the executor, because you have to nominate an executor to the will. And also I always say nominate 1 or 2 executors, because what if you and your executor in certain incident pass away together? Then you're a donor, right? But I'm saying leave the paperwork in some place. Will is just one 10-page, 12-page, 30-page document. You have original title deeds, you have mortgage deeds, you have insurances. Make copies, make sets, digitize, leave the pathways, put them on drives, make them accessible to the newer generation. That is the real financial planning. The person may find the will, doesn't find the property card and doesn't find the property document. What are you going to do with it? Then when you have condominiums or when you have societies, make sure that your nominations are given so that your nominee and your will talk to each other in the same tandem. Now you've gone and put a nominee as person A and the will is leaving it to person B. Whether you like it or not, you've left them to fight about it.
Then there's a natural conflict there.
It is. And that is what will then land it. They may not even fight. But let's say they don't fight about it. But the law does not talk to each other.
Yeah, the legal compliance will be very difficult.
Will be so difficult. So there is a lot of other health check that you need to do to make sure that your will takes effect. And to that extent, every family structure, dynamics are different and therefore take the right advice to do it properly.
So what exactly is the law of limitation in this? What are the, on what grounds can they be limited?
No, so there is no law of limitation for every act. So there's something called the law of limitation, which says that if a cause of action arises, a cause of action means the right to dispute something arises for a person A. The person A needs to bring up that before the correct authority, whether it is a court or a quasi-judicial authority, within a fixed period of time. If they bring it outside the fixed period of time, provided it is still a reasonable delay, you need to get the delay condoned by that authority as to why did you not bring it in time. If it is an unreasonable delay, extremely difficult for the authority to condone the delay. But there are certain acts that stay outside of all of this, criminal acts. There is no law of limitation on you're accused of a crime 30 years earlier. It comes to light today, you can still get sued. But otherwise, for civil cases, there is a rule of limitation. From the time the cause of action arose or you got to be aware of the cause of action, you need to come to the authority within a reasonable time.
Okay.
Because evidence loses value. It's so difficult to go back in time and find things.
Definitely.
Another hypothetical question, which I am coming to you from movies. There are many numerous movies made on, succession, etc. Kya ho jata hai. Especially Bollywood, the 70s, 80s, they used to have these movies where they used to always show this one scenario where there's a well-off set of parents and, they go on a trip and, they meet with a road accident or a plane crash or something and they're gone. And there are 2 little children in the house or, there's a little child in the house who's clueless. And then typically they show that, okay, there was no document. Or even if there was a will made, it's hidden, the child does not have access to it. And then there's usually this one evil bua or fufa or a chacha or someone who comes in, steps in and, says that, okay, I'll handle the kids, and I'll take care of them and all that. But he usurps the entire wealth. So is that really possible that they can just take it away without a will or with a will?
Is it possible? It is. If they have, let's say, if the will was not made in the correct format or if the will was not available easily to somebody, can they forge signatures and get things done in a different way? I won't say it's not possible. Maybe difficult if you do it in the correct process, if you digitize it, if you register it, all the more difficult. If your executor is somebody who you've nominated, who you know that is a strong person with a strong backing. There are many people who nominate law firms as executors. because then it's so much more
So that's
difficult.
more than one person.
So that's one person, plus there is a firm, there is an ethic rule, there is a governance rule, and then you can't just get away with it. But if you ask me plainly, simply, can you mess with a will? Yeah, unfortunately, you can.
You can. So is there anything like a perfect solution to this? What would be the ideal solution to this?
Well, it's not 100% perfect, but if you can, so I'll tell you what I've done. I have decided that to the largest extent possible, I am going to try and bring my child onto the cap table that we call it. So the asset table, the ownership table, to the largest extent possible from now on itself. Okay. And I am going to, what I want to leave it for my mother, or what I would like to leave it for my nephew, nieces, or even my brother, or even his wife. I want to leave something for even his wife. I would rather make sure that that is taken care of right in the beginning, back it up by the correct process of doing a will, register a will, and I will make sure the executor of will is somebody who is not immediate family. Because family does have an emotional bond towards somebody a little more, towards somebody not so much more. And that personalities shouldn't shadow the execution of a will. Now, is this 100% solution? Well, you can't guarantee. But is this a difficult solution for anybody to mess with? 100%.
Okay. So that's another way that you put it at.
Yeah.
Another question I had is that so far, whatever we've discussed is, more about the breadwinner of the family, the bread earner of the family. If something happens to him or her, and the breadwinner could be a woman also. So, this questioning and answers that we've had so far, the conversation has been more towards that. On the flip side, now let's say, suppose there is a homemaker who passes away, and she owns certain heirlooms, certain jewelry, certain, shoes, expensive bags, etc. and all that. Now, who decides? And she's not made a will, because unfortunately, like you mentioned, most of us don't think of all these things. We just think कि ये तो will तो बुढ़ापे में बना देंगे. Day-to-day life में क्या करना है? Now, can the husband have the full authority to distribute her assets, whatever they may be, to the next of kin or to whomsoever he or she wants? And can the children dispute that?
So the law of succession will follow, which is a codified law for every faith that you belong to. Whether it is the husband or the wife or whoever, it is the law of succession that will follow. The court will follow the due process. The court will nominate an executor, and only by that rule it will get distributed.
By an executor? By
an executor appointed by the court. Now, could it be the husband? It could be. Can it be somebody else? It can be. If the court does not feel that the husband is the right authority in this. And, doing a will has got nothing to do whether you're a bread earner or a bread eater. It has got to do with the fact that I am an adult, and by law of being an adult, I have either an asset or a liability that I attract. It's as simple as that. You may have a house husband who takes care of the house, does not step out to do financial income for the family, but has joint accounts, has mutual funds, has an insurance, has a bike, has a fantastic guitar. Are those not assets that need to be given? So, earning or not earning and eating has got nothing to do with making a will. Are you 18?
I'm 19.
You're 19? And do you have any property that you own?
Well, not in the traditional sense, but yes, I do.
Then why not make a will? I'm not trying to freak or scare you.
I understand.
I'm trying to tell you that, look, you would also like something to be done with that property as you matured. Why not put it in a document and close it? Change it.
From time to time, you can change it.
Yeah, of course. Now, don't make a habit out of it to say every January 1st, now I'm thinking something differently. So, do reach a mature age. Otherwise, you're going to have a lawyer on retainer for wills. Don't do that. But yes, you would. If I was to think of it, when Ayush comes back after doing his law, and because I am making a very conscious effort to put him as a joint on everything, I would ask him to get to see an advisor and do up a will.
The day-to-day transition of running the home should be smooth. Where the discomfort should not be felt at that level also, is something that we did. So what's your advice on that? Is there any template for that?
Well, frankly, no template, but I have also done this, and I call it my book of instructions.
Book of instructions.
Yeah. Then I have left it to to, now I'm close to my brother's wife and I've left instructions. You're talking about these things. I'm even simply saying the day they have to walk into my room, how do they know where is what?
Yeah.
How? So
because we all live in silos.
Yeah, we do, right? Because, one is we live in silos. The second thing is I have a particular way of managing my wardrobe. I have a particular way of keeping my investments in one place. I have a particular way of keeping my medical records in one place. I have left instructions to the extent of where is what, how do you access it. Then comes what you do with it. First is go and search it. There are cases where I have had tremendous effort in the family when we've lost somebody to even find out where is the will. I know she made a will.
But कहाँ रखा है?
The executor knows she made a will, but will है कहाँ? अच्छा will मिला, but वो locker के अंदर था. Now who knows the access to that locker?
Locker की चाबी कहाँ है?
That it was a digital locker. We tried everything possible, then got a blink saying it will now lock. So these are the things that you need to think about. Where is what? So I have made a list of instructions. There are many things that will not go into the will, which is why your letter of wishes, your list of instructions is as important. Come a time in life, it's also important to get people involved, along with you to make them understand a particular setup. We are becoming more and more nuclear families. Something happens to one person, there's quite a possibility that a lot of wealth and a lot of asset is going to go unnamed. So it is important to start putting these instructions down and making it visible to 1 or 2 or 3 people. Like, for example, in the digital world, most people don't know there is a concept of most sites, most apps, most platforms, the right to be forgotten. Nobody does that.
Right.
But I have gone on every account of mine and said that if you do not see an account activity from me, I need to be forgotten. Because I may not even I pass away. Somebody doesn't have access to my Gmail. My Gmail is going to get hacked into. My Facebook is going to get hacked into. There are frauds that are going to get perpetrated. The identity is going to be stolen. So what happens to all of that persona of mine on digital media?
Can you just elaborate on that act of being forgotten? I mean, I didn't really get the...
So there's something called the right to be forgotten. Like there's a positive consent for people to take your data. So whenever you do, I agree on various websites, cookie policies for that matter. There is something that I agree to share my data to certain extent. There's also something that they're mandated to give called the right to be forgotten, where you have to ask for it and then you have to fill up the form and say, I would like to be forgotten if you do not see an activity from me for, depending on the app, nature of the app. So if it's a renewable app, then you say 300 days. You don't see activity, nothing to be forgotten. My data needs to be deleted and my account needs to be frozen.
And let's say someone has not clicked on that and done that process, etc. For example, I'll give you an example. Now, there is a particular thing that just came to my mind that, a spouse passes away. He or she has, on her credit card, or debit card, there are certain monthly subscriptions or things like that, he or she has clicked on and the credit card is attached to that and it's being paid on a monthly basis. Now, when that person passes away, how does the other left behind family change that? Okay, that, we don't need these subscriptions now. But without access to the username, password, without access to those keys and all, you can't do it.
All you need to do is, ideally, you are not authorized to use a credit card of the person after he or she passes away. But we all do it.
But the banks or certain subscriptions are using it anyways.
Correct.
Because it's automated.
Correct.
So how do you stop that automation then when the person is
the only way to go through is through the financial institute that gave the credit card.
Okay.
To go and stop it. There are many. Apple subscription run for hundreds and thousands of people who've died long ago. Your Gmail subscriptions carry on. Your Facebook accounts carry on. Your payment apps carry on.
Has there been any case like this, like you mentioned, where, a will has been made? The executor knows that the will has been made. The court knows it. The children know it and all. But like you said, we don't know where the will is.
We even knew where the will is, but we couldn't access it.
Yeah. So if you can't access that will, then what happens?
When you go to the court to get a right to access the will, we had to do that. To just break open the locker. You can't simply go and break open the locker in the house. It took us 6 months to get an order to even break open the locker. Then they allowed somebody to come and break open the locker. Then we waited for that person's, then you have to have witnesses and then you have to do all the process paperwork. 8 months later, the locker was broken into. Unfortunately, the locker was embedded in a wall in the house. There was a waterproofing issue. Water got in. The locker wasn't that well done. So we had a will that we accessed after 8 months, which was not even readable.
Oh God.
You've
Then-
lost the entire thing.
So when somebody is registering a will, they're technically writing it down. So the lawyer is also aware, whoever the lawyer may be, if they're doing it with a lawyer. So, and if this case happens where they cannot access the will, can they just go to the lawyer and be like, you remember?
It won't be with the lawyer, it is with the sub-registrar. And yes, you can. Now, you must also remember that in India, the sub-registrar systems don't have a great foolproof system of keeping all the wills.
You mean the storage of records?
Yeah. How much difficulty do we have if we forget a document of ours somewhere? That Photos Inco department is one place to go and find something. So the best way is digitize it and leave it with your executors and make sure it is in an easily accessible place.
So, ma'am, another question that comes to my mind is that, there is in your will or letter of wishes, you're putting down a lot of stuff. Now, let's say that, okay, a particular person wants his or her funeral to happen in a certain way, and or he wants to donate his organs. Then there is a sort of a conflicting situation out there, is because if he's put that down in either and or in his or her will or letter of wishes, typically any family, when a person passes away, is not going to first thing go and see his will and open it up and check, what were his last wishes in terms of his, cremation ceremony, or, whatever we may call it. So what happens there then? Can you give us an example of what happens there?
So, my advice always has been funeral instructions or last ritual instructions or last rites instructions. Please do not put it in the will, because we are not so akin that the day somebody passes away, we go and open the locker and open the will. So make a separate document, or through your letter of wishes or instructions, leave the funeral things. Organ donation is another thing altogether. Unfortunately, we do not have a very fantastic single method mechanism of the government for organ donation instructions to immediately get enforced. So every hospital runs a different organ donation program, and there are NGOs that run a program, right? I know Times Group runs a fantastic program. But I have had to find innovative ways that how does that hospital or the Times Group or the NGO know about my death? Once they know about the death, they will come into action and say, look, there is an organ donation form filled up, consents, and we would like to procure the organs of so-and-so. So I follow a list of instruction and letter of wishes format for that. And I have left it with my brother, saying that, look, I will leave it with my brother to say, I would like you to follow a very, very simplistic thing. And I would not like you to burn the body, because I think I fantastically believe in medical research. I would, even if my organs are not donatable because of the health or the reason or because of the nature of my death, please just give it to a medical college. If nothing, they will put it for postmortems, for research. I would like it to be used. And there's no foolproof way of doing it. But I have left these instructions in the letter of instructions, and I would give it to my immediate family to say, make that happen. I don't think.
Any example you can give us where a case went wrong like that?
My own mama, unfortunately, he had told his wife that I would like to donate my organ. Passed away on a Sunday. We got in touch with Sasun Hospital. They said Sunday we don't have anybody. Our officer only doesn't come. Then I said, give me morgue availability. And then the people in the morgue said that no, there is no availability. Then there are other factions of the family who were elder to me, and they said, no, tomorrow is not the right day to do it. So tomorrow, let's say we wait till tomorrow, and tomorrow also you tell us, no, now nobody's checking the body, now
Then
you
what?
cremate. So they said, if you ask us to cremate on that day, then it is Amavasya. We don't want to do it. And I had to take and it is a decision that I regret every day of my life. I took a decision by afternoon to say, it is not possible to do this. We don't have a system that supports it. And I did not want to put my aunt through that another agony of another 48 hours, make people wait and then make them do a decision. And let her believe that maybe my uncle did not find peace because his funeral was done on not a nice day.
Mm-hmm.
And I have taken that, and I think I have not done right by my uncle's wishes. And I can justify by it saying that there's no system in place to do it. But the fact is that I couldn't do it.
It's something that's in your mind always.
It is. And I being a lawyer, I being on so many medical boards and hospitals, if I was not able to get that one thing done, how is it possible for a common man to do it? But the thing is, you have to keep finding the right manner of making it known.
Mm.
That I would like this to be done in a particular manner.
Right. But I think that, there's been a lot of learning in this episode with you today. where where we have understood that, what is the importance of sorting out your affairs without without thinking that, death is taboo. Like you mentioned in the beginning of the episode, that, death is inevitable. It's something that's going to happen to everyone. And given the fact that we live in volatile times, after a pandemic, and they're already talking about another pandemic coming into effect soon, and so many unnatural, unforeseen deaths happening around us. It's very important for us to look at this subject, head on, face it, and put those documents in place so that. And you mentioned also that it should be circular. It should not always be downwards that, okay, I'm planning succession planning only for my next of kin or my children and grandchildren, etc. It should also be upwards and circular for people around you, so that everyone is, taken care of.
Correct.
Because that's what you want, that you want your hard-earned wealth, money, assets to be looked after you're gone, and to be given to the rightful owners. That's what we want here. So if I would sum up this episode, as I understand that there is no age to make a limit, is what I understand from what you said. B is that one should make his will and probably revisit it from time to time, whenever it's required. But that will should be made whenever that person has something, some property or owning something which he or she can pass on to anyone. So that is the right time that one should make a will. And along with the will, you also mentioned that the will is better to be certified and registered by a lawyer and by our government, by our courts. The third thing you mentioned is that you should also have a letter of wishes where you would like certain things to be handled in a certain way is what you give. And also on top of that, you've topped it off by saying that there should also be a list of instructions that you can leave. And of course, that's not a legal document, as I understand. It's more a generic document, where you're looking at trying to, pass on to the next generation or to the people whom you have left behind, that this is how I would like, certain things to be done. So am I right to conclude this episode in this? Is there anything else that you would like to say? Any message to people?
Simply putting, your right to life and your right to control your life can be taken away in a jiffy. These are two different things. You may still be alive, but not legally alive to make contracts. Therefore, you've lost control over your life.
For example, you're in a vegetative state.
In a vegetative state, absolutely of unsound mind, maybe for a temporary period, for a prolonged period. Prepare for these times way ahead. Do not think it will not happen. More often than not, it does happen. And if you leave question marks more than you leave answers, you've not done right by your children or by your parents or by anybody.
Right.
It is not accumulation of wealth. It is protection of wealth, which is more important.
And continuity, like you mentioned. I think the key word being
and
continuity.
Leave a good memory for them. Your death, your disability, any which was is traumatic for people around you. At least ease to the maximum extent possible the process around it. Imagine having your child to not be able to even cry because the child doesn't know where the cupboard keys are. Don't do that.
Right. I think it's very, very important that this topic has been touched upon. It's odd and relevant, and I feel that this will be it's a very meaningful conversation, and I think it's going to help a lot of people who watch this episode.
I hope so.
And I hope that everyone follows these steps and don't approach death as a taboo topic. Please approach it head on. Know that, okay, if you've come onto this planet, you are going to go, and you need to plan properly. You need to visit those documents. You need to document the whole process and make sure that, everyone around you, especially your family, knows where those documents are so that they can access it and execute, what you wanted. Thank you very much, ma'am, for coming on the show.
Thank you very much for having me.
Thank you. Thank you so much.
So as we have learned from this episode, I think it is important to revisit the criteria of forming your own will from time to time. Whatever the possession of the assets may be, however minimal or big they may be, depending on your entire stuff that you want to leave behind, I think this is very important. And please share this episode across as many people as you can, since this is a very important piece of information for everybody, but people should know about it. Thank you.